A breaking news alert from Local 6.
All right, live to the courthouse right now, Assistant State Attorney Jeff Ashton speaking in the case against Casey. We take it live.
Had the entire case redone. What I'm asking the court to do is not privileged. I've cited in my pleadings the cases that establish that fact. The defense's response clearly, I think, concedes that. In fact, the defendant's sworn affidavit does reveal some information about that particular subject, sort of exclusionary, saying what it's not rather than what it is. But the affidavit provided by the defendant does not quell the concerns, because if, in fact, Ms. Anthony has not authorized anyone to sell any aspect of her story, and again, her statement says my story in quotes, whether that includes photographs, videos, etc., we don't know, then what is going on here? Who is selling? And again, the court can note that Mr. Baez's spokesman has acknowledged that Mr. Baez has been selling items related to the story in this case. At this point, I want to present the court with a case that I discovered yesterday. Again, there is no case that is directly on point to this issue, but a case I'm handing to court now, United States versus Gonzalez-Mendez, found at 352 Federal Supplement 173, does have some language that is helpful. Briefly to tell the court about it, United States versus Gonzalez-Mendez. In this case, there was a bank robbery. The defendant is arrested as one of the potential bank robbers. The amount of funds stolen is not recovered. The government files a motion wanting to determine whether the money being spent for the defendant's attorney is in fact the proceeds of the robbery. And ultimately, in this case, the court said no, they were not going to let the government inquire. But what's important is at page 3, the first full paragraph, if you want to follow along. In making its ruling, the court says the following. To that end, courts do not generally become involved in matters anent the choice of counsel or the source of attorney's fees, save in exceptional circumstances such as those triggered by grand jury investigations into non-privileged matters. And the next one, a conflict or potential conflict of interest. So, and this is just a District Court of Appeals judge, I shouldn't say just, this is a District Court of Appeals judge in Puerto Rico, federal judge. But he acknowledges in that case that, in fact, potential conflict of interest is one of the exceptions where the court can make inquiry into matters such as this. And I would just submit that as some influential commentary. The difficulty, I want to address the objection and motion to strike. The motion to strike goes more to defense counsel's objections to us as prosecutors and questions our motives. Again, that is not the issue in this case. As I've told the court, we've been discussing this for many months, and the motion for sanctions, which the court denied and actually I think found that the factual basis wasn't even there, as stated in the motion, clearly is not why this was filed. We are concerned with this case. The objection, however, doesn't state any legal basis. It doesn't state whether the defense believes that this is privileged in some way. I take that as a concession that it isn't. Mr. Baez's assurances that there isn't a conflict will have absolutely no help in the eventual 3.850 that will come in this case. Ms. Anthony's affidavit is helpful in the sense that it clearly waives any confidentiality or privilege that she might claim, but doesn't give us the whole story. It doesn't tell us what's going on and where the money is coming from. The last thing I would say, Judge, is there's a minefield in the path of this case. It's in the distance. All we can do at this point is tell the court the minefield that we see, and I'm sure the court sees this too, and how to diffuse it. The way to diffuse this issue right now is to place Mr. Baez, is to basically do what we said in the motion. Get Mr. Baez on the record And again, we're not trying to embarrass Mr. Baez. We're not trying to have this done in open court. It can be done in camera. That's fine. But we need to make sure that the record is clear of exactly what the situation is, exactly what the financial arrangements are, and that Ms. Anthony knows those arrangements and weighs any possible conflict of interest. There is absolutely no prejudice to the defendant in doing this, none whatsoever. We're not trying to have Mr. Baez eliminated from this case. We're not trying to affect anything that he does. We simply want this on the record now so that 5 years from now, we aren't coming back on this case with the potential of having to retry it, wasting all the time you put into it and all the time we've put into it. Thank you.
All right, thank you. My only job is to determine whether conflict exists. If one doesn't exist, we're fine. If one does exist, then she either needs, she has the choice of waiving the conflict or getting a new lawyer. Having said that, Mr. Baez, why don't you take it from there? I read your objections to it. I have a question or two about your objection and motion to strike. Having said that, why don't you go ahead?
Yes, Judge. I want to clarify a couple things about Mr. Ashton's motion. This is a motion to see if there is an actual conflict, hypothetically, that there might be a conflict. I don't think this is a motion to take a look, even though they request so in their motion, to take a look at my trust account or Ms. Anthony's trust account to see what experts we're hiring, what avenue our defense may be going in, who and if there are resources going in a specific direction to possibly give them some type of insight into our defense. And it is also not an attempt to see if the defense has resources, and if so, how much, so that therefore we can, obviously outspend her. That is a situation that happens with defendants across the country every single day. I certainly hope those aren't the objects of Mr. Ashton's motion. I see him laughing. I don't know if that's a yes or no. But certainly these are the perils of which what he's requesting takes us down. This constant interference with the counsel of her choice, and that began, that we've covered over several months. We're talking bar complaints. There are numerous assertions of alleged misconduct in their gag order motion, and then this today. Where we are is we're on a very thin line of Sixth Amendment interference and due process interference as well. I find it odd that Mr. Ashton's entire arguments keep revolving around post-conviction results, or post-conviction issues, where, I'm trying to defend this case. I'm worried about this case. They need to be worried about their conviction more so than their post-convictions, especially in a situation where I see every day evidence that points to my client's innocence. Now,
Your Honor,
Judge,
hold on. Could we approach?
Briefly. I frankly don't see the need, but come on.
I'll be glad to take it from here.
Go ahead.
Judge, let me object to counsel's last statement, which clearly has absolutely nothing to do with this motion. We have sat through hearing over hearing after hearing in this case where defense counsel has used the podium as an exhibit to make comments to the press that have nothing to do with this.
I didn't call this motion.
Objections overruled. Please continue. Guilt and innocence isn't an issue here today.
I understand.
This has arisen in the event that there is a conviction. Nobody should assume that there will be one. That's why we're going to have the trial. Please relate just to the motion that's been filed. Go ahead.
Yes, Judge. What they're doing in their motion is basically stating, hypothetically, possibly, maybe, there's a conflict that exists. And we are telling you that one does not exist.
Okay.
I've not only stated that in my I've not only stated that publicly, I've stated that in my pleadings.
Let me take it from there, because here's what I think I have to do.